Hi, I'm Erin Bradrick, Senior Counsel at NEO Law Group in San Francisco. In this video on tips for nonprofits, we'll be talking about the difference between private foundations and public charities. Section 501c3 exempt organizations are presumed to be private foundations unless they qualify as a public charity. Organizations that qualify as public charities generally include hospitals, churches, and schools, as well as organizations that receive at least a third of their support from public sources. However, organizations that qualify on the basis of the public support test can tip into private foundation status if they fail to meet that test over a 5-year period. Private foundations generally receive their funds from fewer sources and are governed by a smaller group of individuals. Accordingly, they're subject to more burdensome rules and regulations than are public charities. For this reason, it may be preferable to qualify as a public charity for many 501c3 organizations. With that in mind, let's talk about a few more of the differences between public charities and private foundations. Number one, unlike public charities, most private foundations are required to distribute a certain percentage of their assets each year to qualifying organizations to be used to further their exempt purposes. If a private foundation fails to make sufficient distributions, it will be subject to taxes on the undistributed amount. Number two, private foundations are required to exercise certain due diligence and oversight, referred to as expenditure responsibility, when making a grant to an entity that is not a 501c3 public charity, such as a foreign organization, a for-profit entity, or an individual. Although it is often best practice for a public charity to do so as well, they are not specifically required to do so. Number three, public charities are able to engage in an insubstantial amount of lobbying as part of the overall activities. But private foundations are prohibited from engaging in any lobbying at all. They may, however, make grants to organizations that engage in lobbying, so long as the grant itself is not to be used for lobbying purposes. Number four, private foundations are subject to strict self-dealing rules that forbid them from entering into most transactions with certain disqualified persons who have a close relationship with the foundation, such as substantial contributors, officers, and directors. Number five, private foundations are subject to a tax on their net investment income and are not allowed to make certain risky or imprudent investments of the foundation's assets. Number six, donors may generally take a deduction for contributions to exempt public charities or private foundations. However, a donor can typically deduct a lower total percentage of her adjusted gross income for contributions made to a private foundation than to a public charity. And finally, private foundations are required to file the Form 990-PF with the IRS each year, while public charities file the Form 990, 990-N, or 990-EZ. There is no short form return option for private foundations, no matter how small. When forming a nonprofit, it's important to understand whether the organization will be classified as a private foundation or a public charity. If it will be classified as a private foundation, it's important to make sure you follow all of the rules and regulations that apply, and it may be helpful to consult with an appropriate attorney in this process. If the organization qualifies as a public charity, it should take steps to make sure it continues qualifying as a public charity and doesn't tip into private foundation status. We hope that this has been helpful, and stay tuned for more tips for nonprofits.